Okay. I think we have everyone joined in as attendee. I can see them. So maybe we could get started. All right. Hello, everyone, and welcome to the second day of India ADR week. For those of you who've joined us from day one, welcome back. For those of you who are joining in today, welcome to what I'm sure will be a extremely interesting and enriching session. I have with me a stellar panel of speakers, a lot of whom you may know from before, but it is my duty to very quickly introduce them. I recognize we don't have that much time, and I'd much rather hear them speak, so I'll keep this short. I'll start with how it appears on my screen. I have Jyothi Mani coming from Oman Arbitration Center, who will give us, again, the perspectives of everything they've been doing there in Oman and beyond, and how that may be relevant to an Indian audience. There next on my screen is Robert Stephen from the Dubai International Arbitration Center. Uh, Thereafter is Alexis Merle. Alexis Merle is from the Mediation and Arbitration Center of Mauritius. And last but certainly not the least is Kristin Campbell-Wilson from ArbitrateAD in Abu Dhabi. Again, I think we'll get straight to the point and ensure that we make best use of this half an hour that we have. And maybe with that, I'll start with Alexis, not alphabetical, but well, we need to start somewhere. So Alexis, welcome onto the webinar, and thank you for sparing time to speak to us about it. And we would love to know a little bit more about MARC and Mauritius and everything that's happening there. But specifically on MARC, I know you've done some very good work, a lot of very good arbitrations handling. Is there something in your rules that you think the audience may want to know a little bit more about? Any peculiar features that you want to talk about?
Thank you very much, Vikas, for the introduction and for inviting the MARC to be part of this esteemed panel. To jump straight to your answer. Yes, I think, Vikas, that we do have the one unique feature at the MARC in our arbitration rule, which is called the optional appeal procedure. It is outlined in our Article 38 and our Appendix 6 of our rules, which is obviously available on our website. So in a nutshell, what is the optional appeal procedure? It allows the parties to appeal arbitral awards, but strictly on points of law which were raised by a party during the course of the arbitration. So it is an appeal procedure which is restrictive in a sense, because the point of law must have been raised by a party during the arbitration proceeding. This is a pretty rare feature in institutional arbitration. I know very few other institutions who have it, and at least I think, if I'm not mistaken, I do not know any other institution in the African or the Indian Ocean region who does offer this feature. But I think what is important as well to know about this feature is that this appeal procedure is obviously optional. What we are all looking for in arbitration, obviously, is the finality of the process. So this appeal procedure is optional and can only be invoked if all parties to the arbitration agree to it in writing. So it can be included in the original arbitration agreement or agreed to at any time, but during the arbitration. So this specific feature would give maybe the parties a bit of safety net, to correct potential legal errors. So this is one unique feature of our rules.
No, fascinating, and I think. Sorry, maybe just on that question, a quick follow-up. Is it in some senses similar to what may be permitted under the English Arbitration Act, where there's an optional question of appeal to the courts? Or is it something which, again, doesn't really have too many other similarities across the world?
So the difference that we do have with the optional appeal procedure is that the panel who will be on the appeal will be composed of different arbitrators. So it will not be the same arbitrator who will hear the appeal procedure. It will be composed by 3 new arbitrators or 1 arbitrator if the parties decide to have 1. So it will not be the original arbitrator who would have heard the issue to hear the appeal, but a newly constituted panel.
Fascinating. And just in terms of statistics, have people used it previously, or is there significant uptake for that feature?
This feature has not been used very often, but we have had numerous parties who, when they have came to know about this feature, have included it in the terms of reference prior to starting the arbitration. So we have had parties who have added it in the terms of reference, and we have some ongoing arbitrations which have included this optional appeal procedure. And we are yet to see if they're going to be using it or not. It will depend of how the arbitration will be ended.
Yeah, no. Actually, I think that's actually your confidence in the arbitrators that you handle that, to say even if you had the right of appeal, you won't use it because we're so good the first time around. So I think that's actually an indication of your success. So thank you so much for sharing that, Alexis. That's very, very insightful.
You're welcome, Vikas.
Right. Then moving then with from rules to, there's a lot of buzz about technology and what's been happening in that space. In dispute resolution in general and arbitration in particular, and I know a lot of arbitration institutions are also trying to gear themselves up to meet this this change in expectation of parties. And with that, Robert, maybe I'll quickly turn to you. Have you seen that need coming in from your interaction with parties, and how has DIAC responded to that?
Thanks very much, Vikas. And first of all, just very much a thank you to everyone that's joining us today. It's fair to say, I think, that technology has become ubiquitous in international arbitration. It's used for rapid communications throughout the arbitral process. It's used to overcome obstacles, for example, for virtual hearings. We're doing that today, having this virtual session. So when someone has difficulty attending a hearing in person, it can be used quite effectively and has been since COVID. It's increasingly used for cost, efficiency, and quality reasons. I think if you're practicing today, you're probably using computer-assisted document review, for instance. That's often quicker, more cost-efficient, more accurate than engaging lots of people to go through large collections of documents. It's deployed to make arbitral awards more accessible, more understandable for the parties, but also for other entities and organizations that may need to review an arbitral award, for example, a court when it comes to enforcement or where a challenge application is made. So can we, institutions, ignore this current technological revolution? Well, I think the answer to that is no, we cannot, and we at DIAC certainly haven't. So from case management systems and case analysis to hearing preparation and presentation, arbitral awards, learning development, DIAC has been actively working with several providers of technology over the past 2 years to develop some innovative solutions that will empower the centre and empower parties, counsel, and arbitrators to be more collaborative, more efficient, and more successful. So what does that ultimately look like? Well, in the coming weeks, we'll be announcing a partnership to offer seamless in-person, virtual, and hybrid dispute resolution services. Hearing technology, essentially using the most widely used solution in the world. We'll also be announcing the launch of a new case management system that will increase productivity, improve collaboration, streamline the administration of cases under the DIAC rules. And for parties, that system will even the playing field, hopefully. That will give them the ability to manage, annotate, and work with case documents and content in a secure, searchable space. It will provide them with ready access to submissions, evidence, decisions, and at the end of the process, awards. Potentially in the future, access to AI analysis to help summarize documents, surface key facts, make data connections, the ability to create and organize paginated bundles, hopefully in the future, and organize and track key events and help perhaps develop chronologies and the like for when they're preparing their case. And more importantly, I think on that, provide a dedicated, secure space for the centre, for the tribunal, and for parties to exchange case information, which I think is increasingly important and has been the focus of most institutions, I think, over the last at least 5 years or so. We're also working, just a final point, we're also working on developing a comprehensive suite of what we hope to be engaging digital training courses that will be delivered through an easy-to-use learning management system. And the idea there is that that will upskill practitioners in the wider MEASA region on not only the DIAC rules, but also on international arbitration practice and procedure more generally. And we think that that's important and something that we're very much focused on. So lots to come. And I think our story is probably pretty reflective of what we're seeing at other institutions around the world and in this region.
That's fascinating. And thank you, Robert, in literally 5 minutes for having covered such a wide variety of topics. And I think one particularly stuck with me, which is your focus in trying to bridge that technology divide, because a lot of people do speak about it, right? They say technology is fantastic, but will that really exacerbate that divide between the more affordable services and the more expensive ones? And what you talked about is actually very interesting for me, because you're not only providing a document repository, but you're also giving them abilities to work on that document on your platform, like annotate them and create bundles, which I think is fascinating, because it really then means that institutions such as yours are seeing yourselves as more than just administering the cases, but genuinely helping the parties resolve that dispute and everything that happens through. So I think that's a fascinating aspect of what you talked about, and thank you so much for sharing that. And on that same thing, and because this is really as important, maybe I'll get another view on this, and maybe Kristin, I'll turn to you this time and everything ArbitrateAD is doing. Would you want to share some things that you've been up to in this space?
Yeah, no, so I'm happy to share, and thank you also from Abu Dhabi for inviting me to this webinar. It's really interesting to meet virtually and to meet colleagues at other centers and to discuss these matters. So I have a background in a different institution, a European institution, and we launched our digital platform in 2019. I have spent quite a long time now on the institutional side, and joined that European Centre in 2012. And I have only worked in the digital space. We had a digital case management at the time already when I joined. But what we did in 2019 was to introduce a digital platform for the participants of the arbitration to work on, so that arbitral tribunal, the parties, legal counsel, and communicate with the center that way. And that is something that I have done since I came to Abu Dhabi for ArbitrateAD, which is a fairly novel brand and name, but more on that later. So what we did, we launched our operations in 1st of February, and we administer all our cases on the platform. And what I can say, and why that was important for me to introduce to this center, is that it really proves very efficient. It's very helpful to the parties. It's very helpful to the center in terms of time efficiency. It is very much like Robert mentioned, it is cyber secure. It provides the parties, actually that was you who mentioned a repository. It makes it transparent for all the participants. Everything is notified. Everyone is notified at the same time, simultaneously. It helps this institution, the institute, to track the progress. It aids basically all involved. And an extra benefit when it comes to the institutional side is that it provides more time, or it allows more time to be spent on other projects of the institute, which is speaking engagements, or projects in larger projects that may be related to technology, or updating the rules, or what have you, educational initiatives as well. So from experience, it's really a very good addition to the dispute resolution space, and very much in line with the times we live in.
Absolutely, and I couldn't agree more with the role technology is playing. And a lot of people feel that it's displacing people, but like you rightly said, it really is making space for more creative thinking. Like you said, maybe focusing things like developing your rules, engagement with people, spreading awareness, which really you people are doing a very good job of. So well done, and thank you so much for sharing that, Kristin. talked about technology, and obviously it's fantastic, and we can go on for an entire session on it. But maybe we will move to a couple of other session aspects also, which I think are of some importance. And one aspect of which Robert also briefly mentioned is on improving awareness of institutional rules, improving the skills that are associated with it, etc. And with that, maybe Jyothi, I'll move to you and ask you a little bit of your perspective on how important is the knowledge and skills of users of your institutional rules? And if it is important, then how do you ensure that users are kept up to date on it, and what developments are there, and what efforts are you taking with your center in that regard?
Thank you for the question, Vikas. Thank you, the India Arbitration Week, the panelists, and all attendees today. So the Oman Commercial Arbitration Center is fairly new. They were established in 2018, and the rules were released only in December 2020. We've started receiving cases from 2021. However, like I said, the center is still very new, and the knowledge of the rules and how arbitration works is very important for us as a center. We believe that well-informed users are very important to ensure efficient and effective arbitration administration, mediation, or any other form of dispute resolution for that matter. So at the center, what we do is we strive to have continuous engagements with our stakeholders and the users through events, seminars, workshops. So one of the things that we do is that's something we call the OAC ADR breakfast series that we host every month. We started it this year from April, and we've had about 7 of them, and we start again this month from next week. So in those sessions, we try to have different law firms or organizations speaking about current arbitration trends, case laws, any updates that they could share with the users and the attendees to create to generate deeper understanding for them and the practical application of the rules as well along with it. The other thing that we do is training programs for arbitration and mediation. Arbitration with CARB and mediation with CEDA. Again, the trainers also talk about effectively using the rules of the center, specific modules which are on Arabic and English to cater for both language speakers in the region and in Oman largely. The other thing that we also are planning is, as and when we have our case management platform going live, we will also have a knowledge resource center where we will be publishing newsletters, articles, changes in the rules. We are amending our rules at the moment, and hopefully we finish it around next year. We're hoping, by the time if this platform is ready, we will be publishing the guidelines and the rules and any amendments and the whole thing to create more understanding of the rules, case laws. There was a case last year which went up to the Supreme Court of Oman, stuff like that will be published onto the website. So hopefully that should help the users understand the rules and the application better.
Very good. Thank you so much for sharing with us. And I still remember when I was a student and not too many institutions were there. Institutions like ICC were there. And I remember, I think it was Eric Schwartz's commentary on the ICC rules, which we wanted to get hold of because we really wanted to understand what the ICC rules were. But it was not as easily accessible at the time. And I'm talking about 20 years ago. So to have institutions take a proactive approach to themselves make resources like this available to the users is really, really helpful. So thank you so much for doing that, Jyothi. With that, then I think I'll move to another aspect, which is again of some relevance because we have here a couple of new institutions, a couple of existing ones, some of which have undergone a little bit of rebranding and the like. So to get a sense on what's happening there, right? I mean, what are these changes that we're seeing? Is it driven by user needs? Is it driven by a need to communicate, a new phase, a new wave of dispute resolution in the region? And with that, I'll probably turn to Kristin, who is part of ArbitrateAD and which has done some rebranding of its own in very recent times to just get a sense on that topic, Kristin.
Yes, thank you very much. No, I think it's a very interesting topic. And as you say, I represent a center that recently rebranded, but this is also the second time I'm doing this for an institution, Arbitration Center. And I think the reasons behind differ. While the first time around was called for because of a need to consolidate, and that was consolidate the use of the brand, or the brand name as such, so it would become easier to communicate and to sort of embody one brand rather than being referred to as many different things. As you all know, most arbitration centers have a long official name and then often uses an acronym. In this particular case, ArbitrateAD, so the Abu Dhabi International Arbitration Center, is the result of a restructuring and a reorganization of the old ADCAC Center. And it was very important because we have changed or implemented a number of significant changes that essentially makes it a new center. There's a new governance structure. There are new arbitration rules that are modernized and up to date with all the innovations that are out there and have been done, all the innovations of the last decade or so. So bringing the center to the very sort of forefront of arbitration, a new team, new everything essentially. And it was very important for this center to brand itself as that, and to use a brand name that was not necessarily associated with the old ways of the center, let's say. And I think we came up with something that was a little bit novel and chose not to use the acronym, but rather choosing a different brand name that would be very specific to this new center.
Yeah, I must confess, it does sound more young generation. So maybe the newer lawyers will associate it with a lot better. And like you said, it's not just a change in face, but that's actually a lot that's happened in the background, and it's probably used as a signal of all those changes that you've done. So I think, and that's useful because it brings back focus to the institution and everything that you guys have been doing. Excellent. I've, of course, learned an awful lot, even in the limited time that we've spent, and I'm conscious that we don't have that much time, and I do want to hear from every one of you. So maybe I will ask a question which I would want each of you to answer in as briefly as you can, given we have about 8 minutes, which is anything that you can talk about in terms of anecdotal evidence, success stories of your respective institutions, where something unique or peculiar to your institution was instrumental in achieving the kind of outcome that resulted in that particular case, and anything you can share in that respect. And maybe again, I'll go in the order I introduce people. So Jyothi, if you want to go first.
I don't know if this is specific, but we're dealing with a very high value case at the moment, which is about 46 million Omani riyal, that roughly sums up to 116 million US. And the costs that we use at the moment are very, very low to keep it competitive. And I think on the whole, the parties, including the arbitrator's fees, expenses, and the administrative fees, we charge them 0.3% of the total claim value. So we hope to keep it low for the parties, because we understand that the arbitration can be expensive for the parties, and we plan to keep it low.
Yeah, no, that definitely makes sense, because there's a whole range and series of arbitrations that need resolution. Not everyone can possibly afford the kind of fees that exist in some institutions. So very useful. So thank you. Maybe over to you, Robert, then. Any anecdotes to share?
Yeah, sure. We ourselves went through a bit of a rebranding exercise in 2022, and that was followed very quickly with a change to our rules. And just having looked at our statistics for the half-year point of 2024, and with the 2023 statistics fresh in my mind, it's fair to say that I think parties are now benefiting from the provisions that were introduced in those 2022 rules for expedited proceedings, the appointment of an emergency arbitrator, joinder, consolidation, multi-party, multi-contract disputes. And it is nice to see that those provisions that have been introduced actually being used and used quite effectively. For example, the emergency arbitrator provisions, I think, have been used now on 6 occasions, and on each of those occasions, we've been in a position to appoint an emergency arbitrator within 24 hours. And in all of those occasions where we have appointed an emergency arbitrator, and I think that's in 5 out of the 6 occasions where we've determined that it was appropriate to do so in the circumstances of the case, the emergency arbitrator has rendered a decision and done that in relatively short time period. I think 3 to 7 days is kind of the norm, with the longest period is 14 days. But I think just tied to that, I think one of the biggest changes from a practice and a procedure perspective when we launched our new arbitration court and launched our new secretariat was that we really built a new practice and a procedure that was more akin to what you would expect at an international arbitral institution rather than a regional one. And so what we're seeing today is a really low number of challenges in DIAC arbitrations. It was only 3 in 2023 out of 143 appointments. And I think that's testament to the robust appointment processes and the disclosure procedures that we now have in place, and the transparent challenge procedures that were introduced in 2022. So important changes with the 2022 rules, and we're seeing that play out 18 months or so later.
Excellent, as always. Excellent summary, and so many good points to pick that out from. And I will not aim pick my most favorite of them, just given time. Alexis, anything you may want to add to that, or your experiences to share?
Yes, of course. I think I will try to. We've been talking a lot about arbitration, and MARC has also been through revamping of its rules and its structure and its organization as well. But maybe one particular case I would also like to maybe mention is the mediation part of the center that we carry out. So we also administer a mediation, and I think it is often something that is less regarded, but more attention should be given to mediation cases and how it can help the parties to resolve the disputes. And maybe one example that we had here in Mauritius not so long ago, the MARC administered a mediation case which involved a parastatal body against a private company here, and we're talking about multi-million-dollar claim. MARC appointed the mediator, and the mediation went according to the MARC rules. And despite the scale of the dispute, the parties managed to reach a settlement agreement in half a day, and ultimately preserving their business relationship. So I think that mediation has saved probably millions in potential legal fees for both parties, and also restored the trust between the parties. So this is one example that we have from the MARC here.
Thank you, Alexis. And actually, that hits very close to home, because there's a lot of movement, particularly in India, to encourage mediation. We've had a new Mediation Act that's come in as well. And we've seen even the central government encouraging mediation in a lot of their disputes. And to see and hear from reputed institutions like yourselves talking about how mediation has actually been successful even in complex, high-value matters is very encouraging. So thank you so much for sharing that, Alexis. Kristin, over to you.
Yeah, so as mentioned, this is a young center still, so I don't have many anecdotes yet, I would say. But what I think is interesting to mention, or interesting to me, you know, coming here to a different part of the world and setting up a new center along the lines of, you know, the best procedural rules and the international best practices out there. It's been a much welcome change to the environment and the industry here in the UAE. So I think that is very exciting in itself. And we have registered so far 29 cases. So we are keeping busy. But we have yet to amass, you know, the anecdotes that I will be able to. I can tell you lots of the other institution, but that's for a different time, I think. But yeah, so it's very exciting times in the UAE at the moment.
No, I can imagine. And I think it's really that cross-pollination that you bring to the table, Kristin, which is that, you know, you are able to get those anecdotes from your other institution experience, use that to, you know, fast track everything that ArbitrateAD will be doing in the future is really the beauty of the you know, the world we're in. So I'm sure we will hear a lot from you in the times to come.
Invite me next year, and I'll tell you some.
100%, no doubt. But I think, you know, with that, we are almost to the end of our session, and all that remains is for me to do two things. One is, of course, to thank all of the speakers for taking time out to come and speak to us. And the second one is a very shameless plug, which is of course, I'm a joint secretary of the Arbitration Bar of India, and everyone listening in, I urge and encourage you to become members of the Arbitration Bar of India. We genuinely wish to make a difference in the arbitration landscape in the region, work with institutions like the ones you see on the screen to bring best practices from international to here, cross-pollinate Indian ideas through international arbitrations, and also become part of some of their panels. And I must commend everything that Robert's done, particularly from the DIAC's perspective in the last year and a bit, where I know a number of Indian arbitrators have become part of the panel of the DIAC. So thank you, Robert, and the team for really ensuring that you live by the words that have been spoken in a lot of these conferences. There is also the India Arbitration Pledge, which is doing the rounds, where the aim is to try and get more Indian arbitration practitioners to be arbitrators internationally. And I'm sure all of you institutions are looking at us, and I'd urge you to look at all the fantastic work that people here in the arbitration community in India have done. And we will all work together to ensure that institutional arbitration across the world benefits from that cross-pollination. With that very shameless plug, thank you again, everyone, including the panelists who've been here, for very patiently listening to all of it. And I hope you enjoy the rest of the week. Thank you very much.
Thank you.
Thank you very much.
Thank you very much.